Yes, Dr.
As I start, I have one request. I want to maintain the discipline of the Constitution bench. So I'm requesting your Lordships to give me 5 minutes when your Lordship assembles at 3 o'clock on a most extraordinary urgent mentioning. I won't do it now because it's a Constitution bench. The Lordship is fortunately rising at 2:55. So I'll do that before the other matter starts. And your Lordship will take it that I'm not abusing the process. Your Lordship hears what has happened. But that apart, now let me continue with this.
The mentioning is unrelated to this matter.
Unrelated.
Because I was only looking at
the
point of the bench. Then Justice Narasimha and I will come back for the mentioning, and then I'll assemble in the. Nothing to do with this.
No, nothing to do with this.
Why? Agency.
Well, it's with your Lordship's permission. Well, it's a senior person, in public life called Pawan Kheda was boarding a flight today at around 11 o'clock. At the flight, inside the flight, he was deboarded on 3 sets of complaints, Varanasi, Lucknow and Assam. The section invoked is 153A, 153B, national integration and enmity between groups. And based on a statement, I'm not at all justifying any statement. I may not use that language, even not, but was based on a statement in a press conference, and sought to be whisked away. At the moment, they are at the airport, and being taken away by Assam police at Delhi airport. Therefore, till 3 o'clock they are there, and I'm showing that this cannot be a possible. We are asking for consolidation because now all over the country they are filing these FIRs, and with consolidation,
who's Mr.
stay of arrest.
Who's Mr. Pawan Kheda?
Mr. Pawan Kheda is a spokesperson of the Congress, and he has frequently had interactions with the press. He may, I will for a moment, without going to the merits, have made a statement which many people would not make. Personally, I would not make. But the statement, I don't want to. I can repeat the statement, but I don't want to repeat it.
We take it up at 3 o'clock? Or
that's all I'm saying.
3 o'clock is fine, no?
Yes, 3 o'clock.
Then, okay.
Please tell them till 3 o'clock. Yes.
Have you got some petitions?
Yes, we've got the provisional number. We'll have hopefully a diary number, but at least a provisional number in 3 sets.
Yes. All right.
Now, your Lordships put that question just on rising. So let me answer, ABCD, that particular question. I'll continue with my sequence after, but Lordship put that question, that had you allowed possibly the 30th vote to have worked itself out or other things, then your Lordship would have had, so to say, an actual test.
3 baje
the courtmaster. Didn't to come with the courtmaster. Now, so therefore, you should have allowed that to happen, and then we would have had some idea, is what your Lordship put in a nutshell. There are 5 very interesting answers to it. Directly to your Lordship, very important query. And was a related query of Justice Shah at that time. A. This act was followed on 30th by the swearing in along with BJP persons. Just note, I'll make the point in a minute. Just note, 30th June was the swearing in along with senior members of the BJP. 3rd of July, 3 days later, the direct answer to my Lord's query, not on 30th, I agree. Nothing happened on 30th in terms of the vote. But exactly the same trust vote, if your Lordship will call it, or a vote of a virtually identical nature happened at the Speaker's election. Now, clearly, there is a whip, there is a direction. You can't vote for the Speaker. You are my party, you cannot vote. Voting was done. These 39 odd voted the other way. No proof is required. This is a 2-1B without going into a single fact. I'll give your Lordship the judgments. Each of these acts your Lordship has already held in judgments to be a direct violation of 10th schedule without any facts required. If I vote for a Speaker and I'm under a discipline of my party, you can't vote for him. You don't require anything else, but you only need to see the voting. Did I press that button or not? Nothing else is required to be seen. That is on 3rd. So what my lords is saying, nothing could change between 3rd, 30th and 3rd. 3 days, well, no majority would change. No numbers would change. Then the third answer is the 4th of July. Again, an identical trust vote took place for Mr. Shinde. Again, you were told not to vote. Again, you voted. Same people, same vote, same system, same everything. 4th of July, a trust vote in the affirmative for Mr. Shinde. So my Lord has ample proof. My Lord rightly said, how will we know? We'll have to go into something. This is a very, very interesting case where 2(1)B requires nothing, 2(1)A also requires nothing. Normally, your Lordship, 2(1)B can be a per se completely, but something may be required for 2(1)A. Here is a case where both 2(1)A and 2(1)B are per se. Very rare combination. Fourth reason. So swearing in with the BJP, it's on cameras, everybody sees you. 3rd July Speaker's election, 4th July trust vote of Mr. Shinde. Now, the fourth reason. Even the acts, if your Lordship were to go back, now, these are enough. I'm only giving by way of addition. I don't need to go back. I'm now giving your Lordship the seemingly contentious issue, which is not actually contentious. The seemingly contentious issue, which is not contentious, is that on 21 and 22nd of June, you did not attend a meeting despite a direction in writing. Please attend the meeting. The direction is on record. Your non-attendance is on record, admitted. My Lord will now look at it in dimmerer. I'm trying to make it as simple as possible. No investigation, no inquiry, no evidence. Just look at it in dimmerer. Second event is that you went with the BJP and others to meet the governor on 30th June. That's also admitted. It's on record, in the press, on photographs, on press reports. Admitted, no evidence required. As your Lordship noted, this visit on 30th led to the swearing in, which I've already mentioned. Now, which of these will not fall foul of 2(1)A? Forget 2(1)B, Malus. 2(1)B is more per se. Malus, what can be the defense? I'm asking myself hypothetically, Malus. Your Lordship will also see the practical. Yes. I mean, what can be the defense? That these photographs are forged, all the media is forged. I was in Malus, Timbuktu, I never went to the governor's house. That can be a valid defense. Nobody's taken the defense, you can't. Now note two more interesting things, brothers. Rana, para 48. Lordship knows Rana very well, brothers, the Constitution bench. Specifically says that the act and conduct of going to a governor would constitute disqualification. That's Constitution bench. Citation the 2007 4 SCC 270 PDF page 834 of the first compilation.
It was read yesterday.
Read. Only Malus para 48. So
Rajendra C. Rana.
I beg one.
Rajendra C. Rana.
Correct, Rajendra C. Rana. So Malus, this is very interesting again. The fact is admitted and the law is covered. What is it that a Lordship has to do by way of an exercise is my question to myself. With great respect, nothing, Malus. Fact is undeniable, admitted, and the law is covered. And covered too by a Constitution bench. We are not saying, Malus, I can even, Malus, bow down with great respect in a very contentious issue. Your Lordship says, why should we not send it back? There is no issue here. Now note the second judgment, Srimant Patil. Gives a citation. Srimant Patil is the Karnataka judgment. Para 174 and 176. Para 174 and 176. The citation is 2020, Volume 2 SCC 595. 3 learned judges. This is the
2020.
2020, 2 SCC 595. The PDF page in the first law compilation is 1249. It's starting page, I'm sorry. The relevant para is 174 and 176. At PDF page 1307 and 1308. This holds the second point. Not attending meetings is culpable. This is the inception. 21st June and 22nd June, you didn't attend meetings. This judgment holds that not attending meetings is sufficient to disqualify. So, Malos, in this 5 sets of facts, facts are admitted, law is covered. Now, you can always say that we want to do this, we want to do that, but if there is a purity and a social and a political evil to be controlled by 10 children, then Malos, this requires no adjudication of any kind except Malos, the formality of a notice and looking into it. And what is the, even till today, what can be the defense of this? Malos? I am prepared to accept a new defense today. There cannot be a defense to these things. This, Malos, is the light of, but I had finished on subject 2. Putting to you notice and risk, on your own risk and cost, telling you in advance, warning you. Now, let's kindly consider, why is this principle? It is, for what the phrase my Lord is used time and again, the majesty of the law. It is not an empty rhetoric. Imagine, how much strengthened the rule of law is when your lordships in a rightful case does not one but 2 or 3 things. One, your lordships accepts fallibility. There is a line of cases of actus curiae that we were wrong. Justice Bhagwati, in a case I must thank my learned friend Mr. Sibbal to point it out, said to accept fallibility is no act of heroism. So, then the consequence of accepting fallibility must follow. Otherwise, accepting of fallibility is empty. So, your lordship is now coalescing these principles, actus curiae, ibi ius, etc. Imagine, the strengthening of the rule of law when your lordship says, demolish this building, even though we believe it's going to cause a lot of misery. The last one your lordship did took almost 6 months under your lordship supervision because 3 dates were extended. I believe my Lord Justice, Chief Justice was on the bench. But it happened because your lordship had a finding, had a view of the merits. Your lordship said, restoration of status quo ante is vital for the necessity for the majesty of law. Now, just see 2 striking examples in the 10th schedule when your lordships did this. We have talked about, but we haven't shown that actual para. It will tell lordships against what odds your lordship still said, no, we must uphold the law. Nabam Rebia first and Rajendra Singh Rana second. And this is not at all an upholding of Nabam Rebia. We are challenging Nabam Rebia on the sole point of disabling. The fact that I rely on Nabam Rebia for this, doesn't at all, I'm entitled not to be hit by a stopple on that at all. Now kindly turn to Nabam Rebia, just note the paras. 214.1, 0.3 and 0.4. This was the case, as the lordship remembers. Governor, speaker, preponing date. Your lordship knows now, we've argued for 3 days. Your lordship knows the facts. But see what the court did at the end. It could have found a number of reasons to avoid doing this or not giving the answer or postponing it. Deciding not to decide is also a form of adjudication. But when your lordship is convinced of the merits, your lordship decides to decide howsoever severe the consequences. Let's kindly see this now. 214.1 is at iPad, PDF page 1158. 1158, first volume. The compilation first volume. My Lord is seen, but this part my Lord is not seen. This alone vindicates the rule of law. This alone vindicates the strength of the court system, not only the apex court. And this sends a clear message that, howsoever high or whatever the consequence, the consequence must flow if your lordship is convinced. Now, there could be no more scrambled egg in the context of 10th schedule than amravati. Your lordship's unscrambled it. Please see 214.1. The order of the governor of 9th of December 2015, preponing the 6th session of the Arunachal Legislative Assembly from 14th January to 16th December of previous year 2015, is violative of Article 163, read with 174, and as such is liable to be quashed. The same is accordingly hereby quashed. I'll skip the next one, come to the next after next. 214.3. Now, this is even more important. Well, remember, time had elapsed in between. Navam Revia was decided on, give me the date. This is important, the date is important. 13th July. 13th July 2016 is the decision. Show the first page. 13th July 2016. These events related to almost 8 months earlier. New government had come in. It was very easy to say so many things and not do this. But the court, if I may say, did the right thing in terms of consequence. All steps and decisions taken by the Arunachal Pradesh Legislative Assembly pursuant to the governor's order and message of 9/12/15 are unsustainable in view of the decisions at 214.1 and 214.2. The same are accordingly set aside. It was argued, as is argued frequently, that even if your lordship holds it illegal, the intervening decisions will not be set aside. Your lordship hears those arguments every day from this side of the bar or whatever. But this is, if I may say, it's the constitutional walking of the talk. In case, once your lordship is convinced. Next, in view of the decision at paras point 1 and point 3 above, the status quo ante as it prevailed on 15/12/15 is ordered to be restored. That's 8 months earlier. That's why the date of 13th July versus the date of December 15, there's a hiatus of 8 months. A lot has happened in 8 months, while most of all the government is changed. Otherwise, all these principles, etc., will remain paper principles. Now, in Rajendra Singh Rana, the matter was more directly addressed as a juristic principle about you decide or send it back to the speaker. So that's my next case. Rana is 2007 4 SCC 270. First bunch compilation of case law, PDF page 834. And I will read, with the Lordship's permission, paras 12, 44, 45, and 52, 53. It has nothing to do with the law. It is to do with once the Lordship is convinced, what is the consequence? It's ibi jus, ibi remedium. It is actus curiae. It is consequence. It is subject to. It is warning. All that is the point I'm reading on.
What page did you say was that, please?
The page starts, the judgment start, para 12 is at PDF page 849. 834, the case starts. Here the argument was made squarely, that kindly decide. And the rival argument was don't decide. Let the speaker decide. The respondents, may I read this? The respondents in the writ petition, the MLAs constituting 37 BSP members who left the party, are the appellants in all the appeals, except the appeal arising out of the special leave petition filed by the writ petitioner Maurya. Whereas the respondents in the writ petition, challenging the decision of the majority of the bench, remitting the matter to the speaker, the writ petitioner in his appeal challenges the order of remand to the speaker. The writ petition says order of remand made by the majority on a plea that on the pleadings and the material available, the High Court ought to have straightaway allowed the petition filed by the writ petitioner for disqualification of the 13 MLAs. So squarely the issue is joined. Now come to 43. 44, I think. 44 at page 865. Normally, and if I may say so, the contentious issues in this case would be far, far more than the contentious issues in my case. Far, far more. Normally, this court might not proceed to take a decision for the first time when the authority concerned has not taken a decision in the eye of the law. And this court would normally remit the matter to the authority for taking a proper decision in accordance with law. And the decision of this court itself takes on the relevant aspects. What is urged on behalf of the Bahujan Samaj Party is that these 37 MLAs, except a few, have all been made ministers. And if they are guilty of defection, with reference to the date of defection, they have been holding office without authority in defiance of democratic principles, and in such a situation, this court must take a decision on the question of disqualification immediately. Well, my case has one chief minister, forget ministers. One amongst them is the chief minister, many are ministers. It is also submitted that the term of the assembly is coming to an end, and expeditious decision by this court was warranted for protection of the constitutional scheme and constitutional values. We find considerable force in this submission. This is what the Constitutional Bench is saying. Here, the alleged act of disqualification of 13 MLAs took place on 27th of August. And well, this is only 13. We are 39 in this case. 42 actually, well, there were 3 independents also. When they met the governor and requested him to call the leader of the opposition to form the government. The petition seeking disqualification of these 13 members based on that action of theirs has been allowed to drag on till now. It is not necessary for us to consider or comment on who was responsible for such delay. But the fact remains that the term of the Legislative Assembly that was constituted after the elections in February 2002 is coming to an end on the expiry of 5 years. A remand of the proceeding to the Speaker or our affirming the order of remand passed by the High Court would mean that the proceeding itself may become infructuous. But it may not become infructuous, but it will be great delay. Great delay, and fruits would be enjoyed for even one more second is bad enough. Here, fruits will be enjoyed for months and years. We may notice that the question of interpretation of 10th schedule, the question of disqualification raised earlier in regard to the members of the prior assembly of this very state, which led to difference of opinion between 2 learned judges of this court, and which stood referred to a constitution bench, was disposed of on the ground that it had become infructuous in view of the expiry of the term of the assembly. They will cite that judgment earlier at the footnote. Para 3 of the 10th schedule has also been deleted by Parliament. Though for the purpose of this case, the scope of that paragraph is involved. So, this case involved para 3. In my case, the Lordship doesn't even have para 3. What adjudication is required? Rana involved the pre-existing, non-deleted 3. With great respect, considering that if the 13 members are found to be disqualified, their continuance in the assembly, even for a day, would be illegal and unconstitutional. And their holding of the office as ministers would also be illegal, at least after the expiry of 6 months from the date of their taking charge of the office of ministers. We think that the court is bound to protect the Constitution and its values and the principles of democracy, which is a basic feature of the Constitution. This court has to take a decision. Now, this is important. This court has to take a decision one way or the other on the question of disqualification of the 13 MLAs based on their action in August 2003. Lastly, para 52 and 53, where they conclude finally on the result, on the factual result and the result of the case. As we have indicated, para 52 above, para 52 is 869. As we have indicated, nothing is produced to show that there was a split in the original political party of 26th August, as belatedly put forward in a later point of time. But still the plea of split was on 26th. Now that question the Lordship doesn't have a headache about, no problem. On the materials, the only possible inference in the circumstances of the case is that it has not been proved, even prima facie, by the MLAs sought to be disqualified, that there was any split in the original political party of August 2003 as claimed by them. The necessary consequence would be that the 24 members who later joined the 13 could also not establish a split in
संपूर्ण
the
लग्न
original
बसता
political party as
आराधना
having taken
जवाहर
place on
रोड
26th of
अमरावती
August. In fact, even a split involving 37
किचन गृहिणी से
MLAs
जुड़ा
is
एक
not
अटूट
attached.
हिस्सा
There
जहां
were two
उसे
batches.
मिले हर एक चीज अपनी
batches
सही
there.
जगह पर।
That was also
इसलिए
the
अम्बा
inference rightly
स्टेनलेस
drawn by
स्टील
the
किचन
Chief
ट्रॉली
Justice. In view of our
आपको
conclusion,
लगने
not
वाली
necessary.
साइज अनुसार
In
आपके
view of our
किचन के
conclusion, it is
अनुसार
necessary.
बिल्कुल
Not
आपकी
only to
इच्छा
show that
अनुसार
37
उच्चतम
MLAs are
क्वालिटी के
separated,
किचन
but it is
ट्रॉली
also necessary to
मैन्युफैक्चरिंग
show that
से
there was a
सीधे
split
आप
in the
तक
original
यानी
political party.
100%
The above
वाजिब
finding
दाम, न
necessarily
देखभाल
leads
की
to the
जरूरत,
conclusion
न
that
जंग
the
लगने
13
की
MLAs
परेशानी,
sought to be
आसानी से
disqualified
वॉश करने
and not
हेतु
established
उत्कृष्ट
the
कैरियर
defense or
सिस्टम,
answer to the
साथ
charge
ही
of
स्टेनलेस
deletion,
स्टील
defection
जीना रेलिंग,
under para
डेकोरेटिव
2
ग्रिल
on the
एवं
basis of
गेट
para
भी
3.
हम बनाकर
The
देते
13
हैं।
MLAs
अम्बा
therefore stand
स्टेनलेस स्टील
disqualified
किचन ट्रॉली
with
दस्तूर
effect
नगर
from
चौक
August
के पास
2003
MIDC
Supreme Court
रोड
finding
अमरावती
direct at
महाराष्ट्र।
Platinum E. The very giving of a letter to the governor requesting him to call the leader of the opposition to form a government by them itself would amount to their voluntarily giving up the membership of their party. Here they went ahead. They went with the BJP to the governor. In my case today. If so, the conclusion is irresistible that the 13 members of the DSP who met the governor in August 03 who are responding so and so in the petition filed by Moria stand disqualified in terms of 191 read with para 2 with effect from 27th August. If so, the appeal filed by the writ petitioner has to be allowed even while dismissing the appeals filed by the 37th MLAs by modifying the decision of the majority of the division bench. Hence, the writ petition filed will stand allowed with the declaration that the 13 members who met the governor on so and so, being respondent so and so, in the writ stand disqualified from the UP assembly with effect from August 2000. The appeal is
सारा काम अपने बजट में ही हो जाएगा। वाह जीजी, कोठारी जी ने तो चिंता मुक्त ही कर दिया। मैं कल ही अमरावती आ रही हूँ।
the very existence and raison d'etre
मैंने
of
अपनी शादी की ज्वेलरी भी तो
and for the
जेबी कोठारी
magistrate.
ज्वेलर से ही ली थी।
And no other court can have more power in this regard than the magistrate.
और अपनी सखियों को भी साथ ले जाना।
स्वामी
मधुबाला।
Now, let me turn to some of the quotations. Now it will be more focused in terms of just quoting from some judgments. Kindly take a note, which we go to note. Kindly take a note I have filed.
Already submitted.
A3. It's been sent in the night.
Can you?
Serial number A3. I'm
There is there.
A3. Says brief written submission. My name is there. Not sure I put the date for today because there are earlier submissions. This date is today's date. Although filed last night, I believe.
Today?
Yes. Except, I'm going to add one or two cases. I've got only two cases. That
आपल्याकडे
you also
संत
will write in the
तुकाराम
note itself.
महाराजांच्या अभंगांमध्ये
Problem
दाखले
is,
मिळतात आणि बोले तैसा
Ever
चाले
incoming
त्याची
wisdom
मंदारी
agreement.
पावले हा एक संदर्भ आहे। तुम्ही युरोपात आणि आंतरराष्ट्रीय पातळीवरती ग्रामशी आणि अनेक
Married
विचारवंत जर बघितले तर प्रॅक्सिस नावाचा शब्द प्रयोग होतो ज्याच्यामध्ये विचार आणि व्यवहाराची एक सांधता आहे।
आपल्याला न्यायाच्या बाजूने बोलायला शिकायचंय, आपल्याला स्त्रियांच्या बाजूने बोलायला शिकायचं नाहीये आणि आपल्याला पुरुषांच्या विरोधात बोलायला शिकायचं नाहीये आणि आपल्याला
separate note added on the top. So therefore, there is some numbering issue, but otherwise, you'll also be able to follow it. Short factual conspectus. The formation of, I'll be very quick in the first part. Second part, I'll read it a little more slowly. The formation of a new government on 30th of June was the direct and inevitable result of two orders of the court: a negative injunction of 27th of June, not allowing the deputy speaker; a positive order of 29th of June, allowing the trust vote to be held. Order dated 29/6 made the following. I've read that quotation. Subject to. Subject to necessarily and only means that A, the court issuing is acting in rem, warning that all those who act after the subject to order do so at their own risk and cost. Any consequence, equities, rights, or new status quo, this is important one, consequence, equities, rights, or status quo created after the subject to order will be liable to be reversed and status quo ante restored, since the court has fairly put everybody on notice in advance. Well, I'll just read this case. This is important, along with a couple of other cases. But first, let me read on this section first. I'll read this Indore case, fellows. It's important. It's a constitution bench. The consequence of change of government happened fundamentally because the speaker was disabled, fettered in the interim from discharging his constitutional duties. The aforesaid disabling with the order of 27th of June was clearly contrary to a 5-judge bench in Quixote. I have read that para. Lordship will remember that, 110. Then, Manoj, it disturbed the co-equal and mutual balance between judicial and legislative organs, the latter represented by the Honorable Deputy Speaker. Contrary to detailed Supreme Court judgments, I have quoted them below, Manoj. They're coming. These are only the bullets, Manoj, giving Lordship the propositions. The orders of 27.6 and 29.6 cumulatively and conjointly were not orders merely protected.
If you had warned us forewarned us that you've put it down in writing, I wouldn't have been trying my typing skills, I've typed exactly all this that you have mentioned.
But well, some of this is not going to be there in terms of answer to my Lord's query. The answers to your Lordship's query would have been oral, Manoj, therefore.
Right.
Anyway, so I'll skip, Manoj. Now, there are two principles here which I have not mentioned orally. I'll skip till J, Manoj, your Lordship. Come to K, Manoj. K. Then I'll skip again L and M. K is important. I'm sorry, J and K, both are important. J also, Manoj. If in fact an illegality has occurred, and especially after fair warning through subject to orders, the court's powers and arms are always long enough to unravel any situation, and fait accompli cannot be a defense. That's the point. Then K is extremely important, was purposive interpretation. Your lordships have interpreted 10th schedule purposively to plug all collateral and subsidiary loopholes also. Directly it is not said. But we find 20 ways of circumventing that schedule. Your Lordship says, I will interpret purposively to prevent that circumvention. That judgment will come also. The principle of purposive, in light of repeated and comprehensive exhortations by diverse constitution benches and the legislative travaux préparatoire underlying the object behind the 10th schedule and the mischief it sought to remedy, necessitates a purposive interpretation in a holistic perspective to fulfill the true object and spirit of the 10th schedule and not allow it to be rendered a dead letter or an exercise in futility. Then, Manoj, L is Nabam, M is Rana. Right, Manoj? Now, just, Manoj, you can skip para 1 in Chauhan's case. The first line of the boldface, Lordship may note, it is trite law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision. This is, Manoj, the co-equal aspect. Apart from the Quixote, no injunction aspect. So this judgment, the Lordship will note, Justice Chandrachud and Justice Gupta's judgment. Thus, the principle of respecting the field of functioning of each constitutional functionary requires the court not to interdict either the disqualification proceedings before the speaker or the proceedings in the House. However, in the present case, that I'll skip, Malas. Then Quixote, Malas, 125 and 126. This is not that 110. 125, Malas, just turn to for a minute, Malas, it's in PDF 140 of the first compilation.
That's okay, we can read it from here.
Yes, yes.
You can read it out and then go to 120.
Well, this is 126. I'll also just add in hand. 125 is important also. I forgot to put that. Just note that. The purpose of interlocutory orders is to preserve in status quo the rights of the parties so that proceedings do not become infructuous by any unilateral overtax by one side or the other. Then was Samir Bhojwani, a judgment to which my Lord, the Honorable Chief Justice of the party, though authored by Justice Khanvilkar, 2018. Distinction between molding of relief and granting of mandatory relief held that interim relief can be granted only to restore the status quo and not to establish a new set of things different from the state which existed at the date when the suit was instituted. You've created a new status quo that's very different from maintaining a status quo.
Yes.
Then Manas Bommai in para 8, para 115, it has, however, to be made clear, this is one of 3 judges out of the 7, and it's part of the concurring. It has, however, to be made clear that the interlocutory relief that may be granted to such challenge to prevent the frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its functions. This is even more important than Quixote. This is the origin of Quixote in the 10th schedule. Bommai was not 10th schedule, but the principle is important. And this is one of 7 judges. No, 9 judges. 9 judges. 9 judges, and this is the principle which Quixote applied to the 10th schedule. our conclusion that Justice Sawant's judgment is part of the majority, core majority. Our conclusions, therefore, may be summarized under: if the proclamation issued is held invalid, then notwithstanding the fact that it is approved by both houses of parliament, kindly note this, it will be open to the court to restore the status quo ante to the issuance of the proclamation and hence to restore the assembly and the ministry. In appropriate cases, the court will have power by an interim injunction to restrain the holding of fresh elections to the assembly, pending the final disposal of the challenge to the validity of the proclamation, to avoid fait accompli and the remedy of judicial review being rendered fruitless. Whereas Mr. Hegde never lived to see this benefit, because governments changed twice over by the time Bomai was delivered. But subsequent to that, your lordships will notice that the exercise of 356 has decreased a lot, because your lordship has been very prompt, from the Bihars, the Rameshwar Naths, the Uttarakhonds, the Jharkhands, to the Karnataks. It's the promptitude of the court which has reduced the use and abuse of such articles. Because retribution this way or that way, in terms of judicially deciding it, is quick. In the old days, it used to take time. Now, this Kavita Trehan is the actus curiae principle. I'll not go to it, just read the quotation. In regard to the law of restoration of loss or damage caused pursuant to judicial orders, they quote the Privy Council, one of the first and highest duties of the court is to take care that the act of court does no injury to any of the suitors. And when the expression the act of court is used, it does not mean merely the act of the primary court or intermediate court of appeal, but the act of the court as a whole, from the lowest which entertains to the highest which finally disposes of the case. Then they cite this Kedarnath. Under 144, this is the but-for test. Restore the parties to the position in which they would have occupied but for such decree or part thereof. The but-for test, it is called. Nor indeed that this duty or jurisdiction arise merely under the said section. It is inherent in the general jurisdiction of the court to act rightly and fairly according to circumstances. Then, they consider the submission. I'll skip that. Come to the end of that para 23. It's a long para. The boldface is sufficient, that such a thing was achieved by an ex parte order tends to shake the litigant's face in the judicial process. That will not apply. Navam Rebia, I will skip. Now, here, before your lordship comes to the object, that is para 13 onwards, there are two important judgments your lordship will note. One is Bhullar. This is not there. Lordship may note it down on the side, these three judgments. This is not there. No, but my proposition is not there. Your Lordship may, it's not cited here. First is Bhullar, Devendra Bhullar, the death convict case. 2011 14 SCC 770. It's the PDF 926. And the relevant paras are 107 and 108. Please turn to that. If there is an initial wrong, the court says, I'm sorry, 107 and 108. It's a very important principle. Kindly turn to PDF page 967 in the first compilation. Right? First compilation. 966.
What's the proposition?
If the initial wrong is found, then all consequential things must be adjusted so as to rectify that initial wrong. And second sentence is very important. This principle applies equally to judicial orders. This is very important. Please turn to 107, 108, para number. Which page? 107 is at page 966. Put it here. It is a settled legal proposition that if the initial action is not in consonance with law, I'm sorry, does my lord have it? My lord doesn't have it. It's on substantial and consequential action. The page is 966 bottom. It is a settled proposition of law that if initial action is not in consonance with law, all subsequent and consequential proceedings would fall through for the reason that illegality strikes at the root of the order. In such a situation, the legal maxim, it is given there, meaning thereby that the foundation has been removed, structure, work, falls, comes into play and applies on all scores. Now, the next para is more important. Next para. In Badrinath and Kerala, this court observed that once the basis of a proceeding is gone, all consequential acts, actions, orders would fall to the ground automatically, and this principle will apply to judicial, quasi-judicial, and administrative proceedings equally. This is the meaning of majesty of the law. Well, I'll just take a little bit of time on Tuesday, but I won't take very long.
Nice. On Tuesday.
Very deeply obliged.
Be difficult to argue one by one.
I agree.
Both at a time.
Malas, posterity will also get to know what foolish arguments we made, Malas.
And also good arguments.
But nobody
And of course,
admits. Nobody admits.
But it's we will, of course, this will be a great record for the court.
Yes, yes. No, I think it's a wonderful idea.
Truly a court of record.
Yes.
Because every word is recorded.
It should be. It should be.
Every word is recorded.
Malas, in fact, I can share something with you. When Malas practicing in New York, we have these EBT proceedings, that is examination before trial. And I'm talking about this, about the 70s. Malas, they would record everything that was said in the course of that examination, even then. So that we know, lawyers knew what was going to happen.
Gujarat has e-court in the sessions division, sessions courts, where even our internal whisperings are also recorded.
That's very dangerous.
Do you agree?
That's
hazardous, completely hazardous.
Now, the only thing is that if there are two or more voices at the same time,
Yes.
that causes a little bit of a problem. But they obviously have personnel who will clean up the errors by the evening. They suggested that during the course of the day, the council will get the link, so the council can look at it. By the evening, they would have cleaned up the entire transcript and given it to us. So
That's wonderful. That's wonderful. That's truly
In VC
Truly
proceeding,
a milestone, I would say, Malas.
in VC proceedings, anybody wanted to interrupt would lift their finger. So much there is no crosstalk.
That's
So
right.
we can follow that so that it won't
Hopefully.
overlap with one another.
So, Malas, let me just give your lordships a broadside view, Malas, of what is in issue here. Then I'll go on to the matter in some detail. Malas, as your lordship knows, Malas,
pen drive last time ka. Yes.
what is in issue is whether
Last time ka.
the legislative party, that's the central issue, whether the legislative party in the House acts independently of the political party. That's the central issue. Because I will, Malas, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule, and in that context, interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, there is an umbilical cord link between them while they are sitting in the house and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. The bill is introduced by the Treasury benches, any bill.
So is it your contention, therefore, Mr. Sibal, therefore, that unless there is a split outside the House,
Yes.
within the political party,
Yes.
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention.
It could
That's the law also, and I'll demonstrate that to your lordship. That is the law. Well, what happens, I'm giving your lordships an example, A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. What happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now,
Yes.
there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
There's a problem. Supposing, all right, then let's analyze that for a minute, since your lordships have raised the issue. Supposing there are 10 members of the legislative party in the House, right? And the merger has to take place of the political party. They belong, say, to the to the Samajwadi Party, right? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So therefore, Samajwadi Party has to
merge. But no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the Speaker cannot take a decision within the House, within the
Election Commission did not
whether
decide.
there is a merger or not. That can't be.
No, Election Commission did not decide this issue,
How else?
Because a resolution will be passed that we have merged, and that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue.
Actually,
Not so.
Let's have a broad now framework of the facts, because
I will,
in fact, that was our basic problem there. Unless we have a clear perception on the
I'm going
facts,
to
it's
do
very difficult for us then to look at the law divorced from the facts.
I entirely agree, but just, may I just, Your Lordship, what are the issues that are going to be? I just told Your Lordships two.
We have to necessarily reframe the issues, because the issues which are there, which are
Yeah, it's not reflective of what needs to be decided. I agree entirely. The other issue is, and that's never come up before the court, and that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Well, that's one of the issues that Your Lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before Your Lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yes, that's correct. That's correct. That's correct. Because under the 10th schedule, it is the speaker to decide, Mullahs. Correct, Mullahs? But if the proceedings, Mullahs, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Mullahs, how do you deal with an issue? And that, Mullahs, because the last question in the reference is the powers of the Election Commission. And Your Lordships, and that's the last question, which is the last issue Your Lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the... That's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your Lordships only, Mullahs, as Your Lordships will remember, in September said no stay. But Your Lordship did not say how he is going to decide it.
But that, Mr. Sibel, is your independent challenge to the order of the Election Commission.
That's a separate issue, Mullahs.
We can't really decide.
No, that's part of the reference, Mullahs. I'm going to argue, Mullahs.
How do we...
He's saying
constitutionally, the Election Commission cannot proceed. The split would have to happen on 21st of June. There was no whisper of a split on 21st of
Your
June.
contention that therefore the Election Commission itself cannot proceed until
Yes.
the Speaker has decided.
Correct, correct. That's what your Lordship said. No stay, fine, Malaf, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Malaf, when your Lordship sit at 3:30. But be that as it may, that's the last question that your Ladyship will have to look at. So these broadly, Malad, are the issues that you might be asked upon to decide, Malad, that you might wish to decide. Now, Malad, let's go to the list of dates, because unless you have the facts, Malad, it will be. Malad, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learnt how to use the iPad.
Mr. Sybil, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to review?
Yeah, I think it's a good idea.
Call before we
Reference
proceed
order.
further.
Yes, reference order. Your Lordships will have that. Order compilation bullets. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
Is the order dated?
It is on order dated, Mallards, 23rd of August, 2022.
Page 28.
Page 28, Mallards, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right?
28.
PDF page 30, Mallards.
28.
Your Ladyship has it? Justice Shah, Mallards?
Yes.
May I, Mallards? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Mallards, I've already argued that. So Lordships, Mallards, have deferred your Lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the Speaker? Actually, B and C are together, Mallards. They are interlinked.
Per se cases.
Yes. The language is somewhat, Mallards. D, Mallards, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Mallards, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Mallards, if the decision of a Speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, F, I think, is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. I can give your lordship's documents to the effect. What happens is, when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the House for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between the government, between government or the opposition, whichever party it is, and the House, members of the legislature. That's why your lordships will see that nowhere in the Constitution does the word political party is referred to, except in the 10th schedule. Because in the Constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government, and whether the same is amenable to judicial review? Well, it's a governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon. As a governor, who represents he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, in the early hours of the morning, gave an oath to the oath of office, made somebody a chief minister, and by the early morning, on daylight, he had to resign. Governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, the last one. What is the scope and the powers of the Election Commission of India with respect to determination of a split within a party? That's where, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
Submission.
That is A, right? A, petitioner written submission.
Yes, A. PDF 108.
Written submissions of the petitioner.
Return submissions, no?
Yes.
You are referring to return?
Yes.
Not additional return submissions. Not additional return submissions.
A, madam. A. Page 108, PDF.
Mr. Sibal, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues. Because many of the issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I said that
let's
already.
sort of structure that so that it lends some clarity to...
Well, let us do that in the evening. Well, that would be much easier for us.
Difficulty.
If your lordships will allow us, because I'll consult my colleagues.
Yes, absolutely.
We'll give some agreed issues.
In the evening and give us some agreed issues which will arise.
Because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will.
And also then we can have some idea about, the time schedule, how long would you take? So that then we can restrict them as well and to certain time.
This side, will take 3 days.
Mr. Sibal, how long would you take about? 3 hours or so today?
No, Maharaj, I'll take much more tomorrow too.
Sibyl, we'll have to have structured arguments.
All right. It'll be structured, Maharaj. I'm not going to repeat myself at all.
Same.
Your Lordship knows I myself, Maharaj, reduced,
After Mr. Sibyl, after you conclude, Dr. Singhvi will...
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, maybe we could do this. We have about an hour and 15 minutes before lunch, and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give Dr. Singhvi until lunch tomorrow.
Yes.
And then a little supplement to half an hour after lunch for Mr. Kamath.
Yes.
And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude by maybe lunch. And then we give you...
We'll try that, Maharaj. We'll try that. No issue, Maharaj. We'll certainly try and speed it up. I just think, Maharaj, your Lordships may have questions yourselves.
Oh, of course. If we find that, of course, there's a little change in the time schedule, we can certainly do that.
Then, Maharaj, your Lordships will also have to decide on the Nabam reference at some stage, what your Lordship wants to do, because that sort of opens up another...
So we'll look at the list of dates?
Yes, Maharaj. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position, as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, there is an elected government. The attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, Malad, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Malad, please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, Your Lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly, with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to Your Lordships, now there's no question of majority, minority, 1/3, 2/3, not relevant, if there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, my lords, 23rd of January, organizational elections of the Sena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordships, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, my lords, October 2019 elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, my lords, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Agadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, mullahs, have been conducting themselves. How can a governor have sworn in somebody as a chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November?
Yes.
Supreme Court's order?
Yes. Oh, the order, I just... 2019, 10 SCC 809.
Tell me later.
Yes. Then it's mentioned. Anyway, April, May 2020, governor has been at loggerheads with the MP. 25/11. Oh, 25/11, Sunil Prabhu. Now this is important. 25/11, Sunil Prabhu was appointed as chief whip of the Shiv Sena legislative party with the blessings of Uddhav Thackeray, president of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordships, may actually, if Your Lordships don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right. Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thakeray's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat for in the Legislative Council which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or Then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. Malas, I'm not going to rely on these facts, Malas, because this is disputed. So that these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has, along with certain others delinquent MLAs of the Shiv Sena, gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21/6, these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which your lordships has to constitutionally consider. So a faction, which is the legislative party, decides that I will change the whip. Constitutionally impermissible. Then, Millets, the decision, then Millets, Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, Millers, because, as your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, Millers, in the meantime, somebody had to be appointed, Millers, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read, 21st of June, dated 21st of June, received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, the legislative party or a majority of the legislative party can decide who they're going to be the leader of the party in the House, of the party, sitting in Assam. 22nd of June, simultaneously a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. The Shiv Sena Legislative Party in its meeting took note of Shri Eknath Shinde and rebel MLAs and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shiv Sena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM? CM Malaz is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. June 23rd, Sir Sunil Prabhu filed disqualification petitions under Para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shiv Sena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the Speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shiv Sena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly disqualification on ground of defection rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June, 2022. On 25th of June, the National Executive Meeting of the Shiv Sena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the President of Shiv Sena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs, and signing the said resolution on the letterhead of SSLP. Also, the ground taken against BJP MLA was that the said MLA voluntarily gave up membership of his original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Party to submit their written submissions up to today, today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here, as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to this, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. There was nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, Malaj, we don't want to go into it, a majority or even a minority of MLAs are just, Malaj, let's forget the majority, Malaj. Supposing a minority, you don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, Malaj, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed, Malaj, on a disqualification petition, that no. If a petition is filed, you can file your reply after 10-15 days, Malaj. In the meantime, the minority gets in touch, Malaj, with the other party, topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced, Malaj? This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, Malaj, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, Malaj, 27th of June. As several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, Malaj, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Sena Bala Sahab. And you are sitting in a state ruled by the opposite, ruled by a party, Malaj, which was in the opposition. First you go to Gujarat, then you go to Assam. There is no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide, given these facts? Then 28th of June, Malaj, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June, to the then Chief Minister, directing him to face a floor test in the House on the very next day, 30th of June. It is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the Assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this Honorable Court seeking a stay. So, Malaj, we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule were pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given a thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha on 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceedings before the deputy speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And the proceedings of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing, brothers. Proceedings of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, brothers, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality because the judicial order itself says that it's subject to. So you cannot say now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned. Because he knows the writing was on the wall, having given legitimacy to those who... Then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the Chief Minister and Devendra Fadnavis as the Deputy Chief Minister of Maharashtra. The Honorable Governor thereafter directed Eknath Shinde to prove his majority on the floor of the House. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shiv Sena political party, Shri Shinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shiv Sena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July, after all this was over. And the petition for getting the symbol was filed on the 19th July, on the very next day. Then, Malaks, one second. Yeah, I'll take it. Then, Malaks, 1st of July, 2022, Shiv Sena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shiv Sena and change in the organizational setup of Shiv Sena thereto. Also, by the separate letter, the Shiv Sena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Samant from the organizational position of Shiv Sena. Similarly, the Shiv Sena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gulab Rao Patil from the organizational position of Shiv Sena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10 scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July. The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shiv Sena. So this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then 2nd of July, Sunil Prabhu, acting as Chief Whip, issued a whip. Now, till that day, Sunil Prabhu is still the whip. Acting as Chief Whip of SSLP, issued whip to the members of SSLP regarding the election of the Speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shiv Sena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shiv Sena. So if they belong to the Shiv Sena, then how can they disobey the whip? And vote for a BJP candidate against the Shiv Sena member. There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party, was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shiv Sena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. Now you will see on the evening of the 3rd, after
how many votes did the rival candidate poll that day?
Sorry?
July. How many votes did the rival candidate poll on the 3rd of July? Speaker.
That's all. We are not mullahs on majority minority. Yes, that's correct. I'm glad that my learned friend pointed it out, mullahs. Correct.
But therefore, if these 39 are excluded from 164, they still have 125.
I am not mullahs on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, mullahs. I'm not saying, mullahs, whether he would have. Supposing, mullahs, all of them are disqualified, because on that particular day they voted against the whip.
These 39.
All 39.
No, but therefore, if you exclude these 39
yes,
from the 164,
yes,
they're still down to, they still get 125, right?
That's right. The fact
your lordship is right, mullahs. At the moment, mullahs, I am not challenging. At the moment, mullahs.
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
Yes.
So this is now an indicator within 3 days.
The trust vote happened on the 4th.
Because, Mr. Sibal, you don't
happen on the 30th, mullahs.
Right. You don't, ultimately, you don't face the trust vote.
Yeah, I don't, mullahs. So therefore, it is held on the 4th. And we challenge the trust vote also. We've challenged all decisions, the election of the Speaker, trust vote, whatever. All that is challenged. Well, the question is, at the moment, well, we are dealing with a very limited issue. One, should the courts have given time?
That's a separate issue because it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, Mullah? These people were able to topple the government without the disqualification petitions having been decided. There was an elected government, Mullah, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, Mullah, your Lordship holds by these actions, which are uncontroverted, that they disqualify themselves both on both counts, 2(1)A and 2(1)B. What will be the result? And if your Lordship holds otherwise, let's assume, against me, then this will be, Mullah, you have given them a model to topple every elected government.
But Mr. Sibal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the Speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the Speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held, on the 30th.
Yes.
Now, you resign, right, on the 30th.
Yes.
And therefore, is this not really clearly an indicator that even excluding these 39...
That's all right. The Speaker could have been, Mullah. Yes, I'm not disputing that, Mullah. I'm not sure what the arithmetic is. Half 145 is the halfway mark, Mullah.
What my Lord the Chief Justice
You deduct 34, you are below, Mullah. I'm sorry. In fact, the arithmetic is the other way.
No, my Lord, 288 was the total.
Yeah, just give it.
We'll just give you the
strength of the assembly.
The actual, just one second.
Yes.
Total strength of the assembly.
288.
That was there from Mr. Sibal's chart, which we saw.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just one second. Just one second. Total strength
So
of the
half
assembly.
mark would be 100 and...
Just
one second.
Yes.
164.
45.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar if the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those...
just one second.
249, half of it is?
249 and then...
And the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance, even if 39 MLAs are removed...
Plus, there were only 16 disqualifications.
Yes. Plus on that...
As it stands, needs strengthening, even as we say that it requires significant reforms. The views of the Chief Justice and the Collegium are sacrosanct, and they ought not to be overridden by the government or even a subsequent Chief Justice or a reconstituted Collegium. So there is, in fact, in the recent past, where there have been resolutions, recommendations, which have been recalled by a reconstituted Collegium merely because a judge of the Collegium has retired. Right? But that practice is a departure from the primacy principle. Therefore, CJR recommends that the Collegium not to have suo motu powers to recall or review its decisions. The power of reconsideration of a recommendation can only be at the instance of the government and on the basis of any fresh material that the government is able to place, not based on material that had already been placed. So this is what we call the first principle, the primacy principle. And the second principle is the immutability of reiterated recommendations. So these are principles that are there in the judges' cases, which is largely a re-invocation of those. But what does immutability really mean? The President's Secretariat is in effect duty bound to take steps for the issuance of the warrants in line with the collegial recommendations without further reference to the government. That this is something that we are proposing. The President's Secretariat should place the file before the President for the warrants to be issued. The government and the collegium become functus officio once the recommendations, reiterated recommendations go. The third principle that is also perhaps very relevant to what is happening of the recent developments in the case of Madras High Court recommendations, where the collegium has, where the government has been able to split the recommendation, despite the recommendation unequivocally saying that a certain name shall be senior, the other appointments being made without that name being appointed. So this principle we call the indivisibility principle. This is the principle number 3. Each recommendation of the collegium is indivisible. The government's actions to divide and split the recommendation of a collegium is a violation of the principle of CJI primacy. We said this principle 3 is very much derived from principle 1. And CJR would also like to make an appeal to all the split appointees to not take oath or assume office if the recommendation had not been adhered fully. So the fourth principle or fourth norm is that that's the suggestion that had come up. Several of the speakers in the first half of the day had also indicated that there has to be an independent search committee / secretariat. Right, there are two different terms used. We want to put both on the table here to assist the collegium to firm up its recommendations. Right. And the committee is to be independent of both the government and the judiciary. Committee to solicit public feedback on the names within the zone of consideration. The collegium already works on the framework of names in the zones of consideration. So all those in the zone of consideration, the search committee or the secretariat may be able to solicit feedback on. So that's principle number 4. Principle number 5 is transparency and impartiality. There has been significant, it has received significant attention in the first half of this discussions. Therefore, I quickly run through the points. So it has to be no gainsaying at all to say collegium has the responsibility to be an exemplar in terms of transparency and governance norms. All discussions on suitability and eligible to be closely minuted and filed. All minutes except those that relate to the discussion as to suitability of candidates who were eventually not appointed, except those, everything else to be proactively disclosed. The discussions in respect of people who have already demitted office also to be proactively disclosed. And the discussions in respect of those persons considered and eventually not appointed may still be held, and such records to be destroyed or archived only upon such a candidate no longer being eligible or appointed. So that is to say that there is at least on the file, there is transparency even if there is no disclosure. That causes sufficient deterrence in unconstitutional or unsuitable appointments being made. So the last point relates to impartiality. This is something that Professor C. Rajkumar addressed in his speech as well. So no collegium shall consider or discuss appointment of any candidates who is a close relative of any member of the collegium, or in cases where any member is reasonably conflicted. Reasonably conflicted, what amounts to a reasonable conflict, I think the speakers in the panel before had indicated. So the sixth principle, the last principle, is the commitment to increase in diversity in representation, social, regional, and gender. So this also came out of the first 2 sessions that we had. So some of the recent criticisms of the judicial appointments being not being diverse enough, I think CJR supports and endorses that criticism. Collegium to proactively commit itself to increasing diversity. There are factors such as regional representation, seniority, etc., already mentioned under the judges' cases. We say that other factors, including all the factors mentioned in 15, say Article 15, as well as those factors such as disability, be considered. And the search committee, to assist the collegium, must prioritize this requirement. So these 6 principles, CJR sums up as those that emerged out of the discussion earlier. If there are any further principles that we want to add in the subsequent discussion, that we may try and discuss those and see if we can incorporate those in the resolution. Thank you very much.
Thank you, Prasanna. I now invite the panel to please come up on stage. First of all, I'd like to invite Justice Indira Banerjee. She's a former judge of the Supreme Court of India, serving for a period from 2018 to 2022. Her lordship was the 8th woman to be a judge in the Supreme Court, and she had previously served as a Chief Justice of the Madras High Court. She was in the Supreme Court on several important constitution bench decisions dealing with issues from bail, drugs to narcotics offences. Welcome, Justice Banerjee. I'd like to invite Justice Anjana Prakash. She's a former judge of the Patna High Court and a senior advocate in the Supreme Court. She's been speaking out very strongly on various issues affecting the Republic today. A very warm welcome to Justice Prakash. I'd like to invite Mr. Sriram Panchu, who's a senior advocate at the Madras High Court. He has many decades of experience in the legal profession and is internationally recognized for his expertise in mediation and arbitration. Welcome.
How can you live like this? Live Space your kitchen. Get better quality fittings. Live Space. Love the way you live.
I'd like to invite Anjali Bhardwaj, who's a founding member of Satark Nagrik Sangathan, is a co-convener of the National Campaign for People's Right to Information and is also a member of CJR, and Mr. Prashant Bhushan, who's the convener of CJR and well known for his work in public interest litigation. So, having heard many speakers in the earlier 2 sessions, this panel has the work of actually laying out, in some senses, the way ahead. What do we see as the key principles and framework for judicial appointments? And I'll just take a minute to perhaps just point out a few facets that I hope the speakers will be covering. The first, of course, being transparency. We've heard a lot of it in the previous session as well. Diversity. I think the issue of assessments came up, that how do you assess those who are being appointed? So perhaps something around that the speakers would like to reflect on. On the issue of accountability, that once appointed, then what happens? What is the framework for accountability around that? and also perhaps a framework of does something like a full-time secretariat or full-time commission. So how do the speakers view each of these issues? And without taking up any more time, I'd first like to invite Justice Indra Banerjee to please share her comments.
Distinguished panelists on the dais, ladies and gentlemen, a very good afternoon to you all. I'm happy to be here to share my views on a topic which has assumed extreme importance today. In our country, under our constitution, we have the Union Judiciary under Chapter 6 of Part 5 of the Constitution, which is the Supreme Court. Then we have the High Courts under Part 6 of Chapter 5, a High Court for each state. Sometimes we have one High Court for two states, one High Court for a state and a union territory, or a High Court for a union territory for that matter. Then, of course, we have the subordinate courts, which are covered by Chapter 6 of Part 4. The appointment of the district judges under Article 233 and other judges under Article 234. If we go upwards from the lowest level, then so far as appointment of other judges are made, there the governor has to act in accordance with the rules, in accordance with, after consultation with the Public Service Commission and after consultation with the High Court. Since these appointments are made on the basis of a competitive examination, followed by an interview conducted by the Public Service Commission, in which there are representatives from the judiciary, from the Public Service Commission, and from the Law Secretariat of the state as well, there is not much criticism with regard to these appointments. There is a certain amount of fairness. Under Article 233, the governor, in consultation with the High Court exercising jurisdiction, is empowered to appoint district judges. The minimum qualification for direct recruitment is 7 years practice as an advocate. But even these appointments are made on the basis of a competitive examination followed by an interview. Though there are some appointments which may not be that good, because, every system has its pitfalls. There is no complaint really with regard to the system of appointing district judges either.
In 2023, you will be